Meeting in order. Good afternoon. Thank you. You always catch me on that. Thank you for joining the Finance Committee. Today is Thursday, March 28th. I apologize for being late, but a lot of us over in the Senate, I've been over and presented a bill and I'm back. So we're going to start the meeting, and I'm not going to give you bill order because it just depends on how delegates appear. So we're going to start with Senator Mike McKay. He's going to present Senate Bill 1134 and House Bill 787. Thank you, Senator.
Thank you, Madam Chair. Thank you, committee, for allowing me to present today Senate Bill 1134 and House Bill 787. Committee, this bill establishes an Allegheny County Regional Recreational Economic Development Authority. The authority's job is to support and develop and construct a regional recreational facility for the benefit of the area residents and the county economy. It would be both an indoor and outdoor athletic fields, as well as other recreational tourist facility. The authority would report every October 31st, beginning in 2025, its activities in the General Assembly and the governor, and would sunset June 30th, 2029. I ask for your favorable report on both House Bill 787 and Senate Bill 1134.
Thank you, Senator. We have letters. A letter from the Senate and a letter from the House.
From the delegation.
Yes,
chair.
from the delegation.
Well, being that I am the only one I can send you a letter if that you would like. We will make sure that you have that lickety split.
All right. Thank you, Senator. Do you have any questions for Senator McKay? All right. Thank you very much for your testimony. That ends the hearing on Senate Bill 1134 and House Bill 787. I'm going to see who's next. Did he come in next? They were all at one time. Let me start with House Bill 1143, Delegate Bhandari.
Madam Chair, members of the esteemed Finance Committee, for the record, I'm Delegate Harry Bhandari. I stand before you today grateful for our shared dedication to improving ER wait time in our state, particularly addressing our state pressing challenge of the longest emergency department wait times in the nation. Last year, we collaboratively initiated a legislative initiation by sponsoring a task force bill, which led to the formation of an informal work group under the guidance of Senator Madeline Griffith, Chair of the Senate Finance Committee, and Chair Penia Melnick of our committee. We extend sincere thanks to the Maryland Hospital Association for their leadership in this critical initiative. This initiative was in response to the critical challenge of prolonged emergency department wait times in our state, the longest in the nation, according to Center for Medicare and Medicaid Services. I personally would like to thank Madam Chair Bidel for your leadership in the issues and learn a lot from your expertise and wisdom while serving together on that informal task force. Our aim was to assemble a diverse coalition of stakeholders, including healthcare professionals, patient advocates, and representatives from both the Maryland Health Department and Maryland Health Services Cost Review Commission. This collaboration focused on identifying the root causes of the delays and formulating effective strategies to address them. The insight gained have informed our legislative effort this session, including the introductions of this bill, SB 1143. This bill aims to establish the Maryland Emergency Department Wait Time Reduction Commission. The commission recommended to this committee on January 17, 2024, and further developed through our participation in the work group, is tasked with developing strategies to improve emergency department efficiencies and patient care across Maryland. This represents a critical step in our collective effort to address this prolonged wait times through standardized operational protocols, advanced technology solution, and collaborative healthcare practices. The ongoing support from the Maryland Health Department, Maryland Health Services Cost Review Commission, and the Maryland Hospital Association, who all support this bill, and we work closely on the House side, will be instrumental in successful policy outcome. As we propose the establishment of this commission, we are not just addressing a current need, but laying the groundwork for a future where all Marylander have access to timely and highly quality emergency care. Thank you for your dedication and commitment to ER wait time for the people of our state. I look forward to working alongside all the stakeholders to bring these positive changes. And I would like to request a favorable amendment. And in the fiscal note, there is a revised fiscal notes. So it is a huge, but now the Health Service Cost Review Commission will provide staff of the commission. So the fiscal note is reduced.
Thank you very much, Delegate Badari. I was looking to see who was going to staff it. So it's going to be the HSCRC.
Correct.
Okay, very good. Do I have any questions for Delegate Badari? Thank you very much. That ends the hearing on
Thank you.
House Bill 1143. Delegate Anderton,
Yes,
think
ma'am.
I see you next.
Good afternoon, Madam Chair. It's good to see you again. Senators, my senator. Good to see you too, brother. So House Bill 1340 is a local bill that is supported by, I have letters from our senators, our delegates, our county council, county executive, all unanimous, moving forward to allow restaurants to purchase their alcohol outside of the dispensary system, matching what all the counties that border us already have in place. So it's just basically allowing us to be a little more competitive in the mart of competitive commerce. So it's, I have my county executive here. She just wanted to be supportive. This is a big issue that our restaurateurs are looking forward to being able to have more options.
And Delegate, this has already passed the House?
Yes, ma'am.
Okay, and we have a letter?
Yes, ma'am.
Thank you.
Yep, thank you.
Do I have any questions for Delegate Anderton? I see no questions. That ends the hearing. Thank
See
you.
you. Yep. All right.
House Bill 1013, Delegate Sarah Willick. There she is. Thank you, Delegate.
Good afternoon, Madam Chair, Madam Vice Chair, and colleagues of the Finance Committee. For the record, I'm Delegate Sarah Wallach here to represent HB 1013. This bill adds licensed clinical professional counselors to the list of healthcare professionals who can certify illness when a state employee is seeking paid sick leave for 5 or more consecutive workdays. There are 3 main reasons I'm bringing the bill forward for your consideration today. First, HB 1013 aligns state employees' policies with the health occupations law. Currently, Maryland law specifies that physicians, psychologists, social workers, nurse practitioners, nurse midwives, physical therapists, podiatrists, dentists, and optometrists may certify illnesses for state employees requesting paid leave. However, licensed clinical professional counselors are not included on this list, even though they're permitted to diagnose and treat mental health illnesses under the health occupations article. Secondly, HB 1013 will ensure that state employees do not face delays in obtaining leave for mental illness. Currently, if a state employee needs time off because of a mental health issue, they will need to find another type of provider to certify their illness, even though they may be receiving care from a licensed counselor. And finally, HB 1013 aligns with our state's efforts to recognize the importance of emotional and mental health. By recognizing the full range of practitioners who provide care in this space, we will ensure that the well-being of state employees is holistically being recognized and addressed. This bill has no fiscal note. Thank you for your consideration, and I ask for a favorable report.
Thank you, Delegate. Do I have any questions? I see no questions. Thank you for your presentation.
Thank you.
That ends the hearing on House Bill 1013. Do I have any other delegates here?
I did have a witness if there's any questions.
Okay, thank you. We,
Senator Biden, I'm just here for questions.
thank you. I don't see any questions. Good bill. You want to? No, wait a minute. Are you Stephanie?
Yes, ma'am.
Will you hold a minute for me? We're gonna wait just a minute on you. Delegate Solomon.
Good afternoon. Thank you, Madam Chair. For the record, Delegate Solomon, happy opening day to all of those who celebrate. I'm here to present House Bill 1044. It does not have a cross file, but it was not intentional. I'll give you just a really quick overview. We had worked, Senator Rosapep and I had worked, I serve as the Personnel Subcommittee Chair. And last year in our budget, there was language creating a work group within DBM and state government to look at streamlining and improving hiring process across state government. And so this bill originally as drafted was impacting sort of two things that have been discussed during that work group. One was potentially further sort of removing and streamlining the degree requirements for state workers. And another was around the recruitment practices and the kind of overall outreach and sort of recruitment strategies that DBM is using. In working with DBM, we decided that what was originally in the bill would be better suited for budget language for them to work on again during the interim and get back to us in this coming fall. And so I introduced the bill just in case DBM had other ideas. Unfortunately, the timing didn't quite work in the Senate, so DBM then came to us with a set of amendments of things that they did really want. And so the bill, as before you today, basically struck those two provisions that originally were in there that have now become JCR language. And the bill does two very simple things that were recommendations of the state work group. One is to eliminate the 1 week requirement that DBM essentially has to wait a week to review a job description before it's posted on the state website. They feel like they can do that usually within a day. And the other provision that is struck from current law is a provision that does not allow DBM to do continuous ranking of employees. So essentially what they can do if this bill passes now is as soon as an applicant finishes their application, DBM and the HR team can start ranking applicants. So as soon as the job posting closes, they already have the rankings for other applicants. DBM fully supports this. There's no opposition. I think it was near unanimous in the House, and I would ask for a favorable report and happy to take questions.
Thank you, Delegate Solomon. Do I have any questions? I don't see any questions. Easy. Thank you.
Great, thank you.
Ends the hearing on House Bill 1044. I have representatives from St. Mary's County. I think either Todd Morgan or Melinda Sharenko. Linda, you want to come up? You have two bills, House Bill 651, House Bill 654.
Good afternoon, Chair Vidal and esteemed members of the committee. For the record, my name is Melinda Sharenko and I am Delegate Todd Morgan's Chief of Staff. Delegate Morgan is the Chair of the St. Mary's County Delegation. I'm presenting House Bill 651, St. Mary's County Alcoholic Beverages, Beer, Wine, and Liquor Tasting Permits. The purpose of this bill is to establish a new alcohol tasting permit in St. Mary's County. Currently, St. Mary's County has a beer and wine tasting permit for Class A licenses. This bill creates a new permit which allows retailers to offer samplings of liquor products in addition to beer and wine. This is limited to the equivalent of one standard drink per customer. Establishing the new license will permit both retailers and consumers in St. Mary's County to be able to have a new market and test new products. And it's just going to benefit both the local distilleries and the economy and win-win all around for everyone. In closing, the creation of this new permit will benefit everyone and the consumers, the retailers, and the distillers. Thank you for consideration, and I respectfully ask for a favorable report.
Melinda, thank you. I have a question. You called it a standard drink. Is that how you?
Yes, that's what it says. So
How
what it says here is like a 0.5 ounce of liquor for each offering,
Okay.
and a 1.5 ounce from all offerings of liquor that day. That's like all they're allowed to offer.
Okay, so
And
there
then
was I want to make sure there was some ounce definition.
Yes, there are.
Thank you. Do I have any questions at all on this bill, House Bill 651? That ends the hearing on 651. And now if you'll present House Bill 654.
Again, for the record, Melinda Sharenko presenting for House Bill 654 for the St. Mary's County Delegation. St. Mary's County Alcoholic Beverages Nonprofit Performing Arts Theater License. The purpose of this bill is to establish a new liquor license, a new liquor sale license for nonprofit theaters in St. Mary's County. Currently, nonprofit theaters are required to purchase individual licenses for each performance for which they want to make alcohol available to patrons. The reoccurring license fees result in an annual cost approximately to that of the standard license, even though the alcohol is only sold in select performances. The bill creates a new license for nonprofit theaters, allowing the theater to save money on licensing and reducing the St. Mary's Licensing Board administrative load by halting the repetitive issuances of licensing. Thank you for your consideration, and I respectfully ask for a favorable report.
Thank you. We should just do this statewide. We're getting a bill like this county by county, but it's a good bill. So thank you for your presentation. Any questions for Melinda on House Bill 654? Seeing no questions, that ends the hearing. Thank you.
Thank you.
Melanie Wenger, are you here for Montgomery County delegation? So you're going to present House Bill 762?
That's correct. So, Madam Chair, members of the committee, Melanie Winger, I'm the Director of Government Relations for Montgomery County. And we have a county requested delegation bill that's passed both the Senate and House delegation. There was legislation that passed during the depths of the pandemic that allowed counties who had restaurants and bars to sell off-premise beer, wine, and cocktails. That legislation actually expired on June 30, 2023. So what this legislation does is allow in Montgomery County, its bars and restaurants that have Class B beer and wine licenses to go ahead and have pieces of that expired legislation apply again, so that Class B beer and wine restaurants and hotels in Montgomery County would have the authority again that they had under the previous law to sell just beer and wine off premise, not to be delivered, but just off premise. It's the same authority that they used to have, a little bit more limited.
When you talk about the bill previously under COVID, are we talking about?
It was a piece of legislation that passed in 2021, the kind of the height of COVID, to ensure statewide
Mhm.
that restaurants and hotels would have a chance to compete again.
So
In
do you have a letter from your delegation?
Yeah, I'm quite certain that the House and the Senate delegations, they both passed it, and hopefully you do have a letter on file that Senator Kramer, as the Senate delegation sponsor,
have
I hope
House or the Senate?
prepared for you.
We don't have the Senate letter yet.
I'll make sure you get that.
Okay, thank you very much. Do I have any other questions for Melanie on House Bill 762? Seeing no questions, that ends the hearing on Senate Bill
Great,
762.
thank you very much.
Thank you. Next we have, I guess Katie Malone is here to present House Bill 1269 for the Baltimore County delegation.
Good afternoon, Madam Chair and members of the committee. The Baltimore County Administration requested HB 1269 on behalf of Baltimore County's Liquor Board, and we are asking for a favorable report. Current law requires Baltimore County to publish notices of liquor hearings in 2 newspapers. Unfortunately, local newspapers are dwindling. We are down to the White Marsh Avenue and the Dundalk Eagle, and their circulation is fairly limited. This bill brings the Baltimore County Liquor Board hearing process into the 21st century by providing flexibility to properly notify interested parties in multiple ways. Simply put, HB 1269 allows the county to notify the public of liquor license hearings by publishing the hearing notice in a newspaper with circulation in Baltimore County, like the Baltimore Sun, and by publishing the hearing notice online on the Baltimore County website. With that, we thank you for your time and favorable consideration.
Thank you very much. Do I have any questions for House Bill 1269? Senator Mounts, he's having trouble with his button. There you go.
Yeah, and did the newspaper association testify on the bill one way or the other?
I have Amanda Carr with me from the Baltimore County government, and she can answer that question.
No, sir.
No, sir.
They have not
Okay.
commented either way. Thank you.
Seeing no other question, that ends the bill on House Bill 1269. I think Delegate Kaiser's here, House Bill 1304.
Okay.
Thank you, Madam Chair. I was just trying to, my colleague was here before me. To everyone, House Bill 1304, thank you, Madam Chair Beidle, and to the other members of the committee. I'm hearing a bill about requiring state agencies that administer public assistance programs to inform individuals about the federal and state earned income tax credit. As it's designed, or as it's been amended, it aims to direct customer service representatives at the given agencies in this bill, but maybe in future years, other agencies, that when someone is coming in and seeking assistance and seeking help in how to get their assistance, and a lot of times people who have certain needs with our earned income tax credit may also have needs with our homeowners tax credits, may also need energy assistance, may also need other things that come from our health department, Department of Aging, and so forth. So the goal is that when someone seeks benefits in person, whether or over the phone or online from the agency, they should be told about the earned income tax credit. I have some information here. The federal tax credit can be up to $7,400 annually. The state one can be half that much, and it's estimated that over 100,000 Marylanders that qualify don't apply. There have been other bills introduced this session that increase the awareness of the state earned income tax credit. I believe this bill is complementary to those efforts and really will increase the odds that someone applies for the important benefit that helps lift them out of poverty. There's a reference in the fiscal note that this legislation will possibly impact state resources because more people will take advantage of it. And I have two reactions to that, and I'm hoping I'm reading your giggle appropriately. My first reaction to that is how cynical. We create a state benefit. It should then be our goal that people who qualify for it actually use it and that we're not hiding the ball. So of course, if this bill means that another 100 or 200 people apply for and qualify for this state earned income credit, that should be what we would hope for and not the opposite. And then the other thing I would say, as we all know with fiscal notes, they look at the direct costs and direct benefits and not the indirect. And certainly anytime we ensure that we're putting dollars in people's pockets, we should be reducing other needs that they have and other need for benefits. I'll just close with this bill had 63 bipartisan co-sponsors, passed unanimously, and the fiscal note was mostly eliminated because the first round of the bill had mail and email going out to people, but that was not the intent and is no longer there. So thank you, Madam Chair. I urge a favorable report on House Bill 1304.
Thank you, Delegate. Nice to see you here. Do I have
Always
any
a pleasure to see
questions of Senator Hayes?
Thank you, Madam Chair. Elliot, does this bill include individuals who are seeking to enroll in benefits from like the Department of Human Services?
So that's a very interesting question. Thank you. Human Services were in the bill originally, and they were amended out. In talking with the staff from the Department of Human Services, and I know you worked there previously, but talking with them and talking with some of their local providers, they are doing this at every step. They are telling people about it. They are ahead of the curve.
Thank you. Any other questions? Seeing no other questions, thank you, Delegate Kaiser. House Bill 1304, the hearing is ended. Thank you.
Thank you. Thank you so much. Take care, everyone.
Delegate Smith, House Bill 1203.
Thank you, Madam Chair, and thank you, distinguished members of the Senate Finance Committee. For the record, I'm Delegate Stephanie Smith, here to present House Bill 1203. This is a bill that establishes a strategic infrastructure revolving loan fund program. It is intended to catalyze private investment into our communities and return underutilized properties back into productivity for our communities and economy. By making targeted investments into real estate and infrastructure projects that support transformative placemaking, transit-oriented development, community development, or inclusive and equitable economic growth objectives, we can advance goals to support infill, redevelopment, and revitalization across the state. We need a better link between private and public sectors that could build a pipeline of investments to support large-scale infrastructure projects. The extensive experience of the Maryland Economic Development Corporation, often referred to as MEDCO, in real estate development and bond financing makes them uniquely positioned to operate the loan program. Loans would be used to address significant pre-development and initial infrastructure-related project costs, Without this assistance, proposed projects would not move forward given overall development costs and commercial lending constraints. The loan program will generate positive revenue for the state and local jurisdictions by spurring private investment into real estate development. I want to note that this bill does not mandate any appropriation, nor does it specify an intended level of discretionary funding. What this bill does do is it allows Medco, with local approval, to pledge specified alternative revenues under the Tax Increment Financing Act. And I want to also note that this bill would also require implementing regulations to be promulgated by Medco. What's really important for you all to know about this bill is that it had strong bipartisan support. It was unanimously voted out of Ways and Means, and it received support of 135 delegates on the floor. There's only favorable testimony in support of the bill, and it's important to note that there are underutilized structures and buildings in every corner of our state that could be benefited by this legislation, including something like a decommissioned power plant in Western Maryland or some other type of facility in Central Maryland. So I thank you for your attention to this presentation, and I do encourage a favorable report for House Bill 1203. And I just want to let you know that Mr. Sadowski from Medco is here if you have any specific questions.
Senator Hayes.
Then Mr. Sadowski could ask a couple of questions. Yeah. Can you come up, Tom?
Good afternoon.
Good afternoon. How are you?
Excellent. Thank you.
I understand that there's no mandatory appropriation, but throughout the bill, it refers to loans or debt that would be issued. In this case, who would be responsible for repaying that debt?
It would be the private sector developer.
So whoever is actually the real estate developer that's on.
Yes.
They would, and how would you guys leverage the money would there be an expectation that there would be funds that would go into the fund on an annual basis?
Well, there is an expectation of repayment, and we would structure each loan so that there would be a quick repayment. We were looking at a term anywhere from 3 to 5 years. And then those proceeds could be redeposited back into the fund for then redeployment for other projects. It is considered to be a revolving evergreen loan source over time.
But I understand this bill does not require any funding to go into.
Correct.
But is there a allocation that would eventually need to be provided from the state in order to start the fund?
Ideally,
once we get it set
yes.
up or whatever.
Yes,
Gotcha. Okay.
correct.
All right. Thank you, Madam Chair.
Any other questions? No other questions? Thank you. Delegate Smith, thank you for your patience.
Thank you.
Thank you. That ends the hearing on House Bill 1203. Thank you. And now House Bill 1487. Secretary Anderson or someone representing, there he is. And thank you for your patience, sir.
It's more than fine. Good afternoon, Chair Vital, Vice Chair Klossmeyer, and committee members. For the record, I'm Kevin Anderson, Secretary of the Maryland Department of Commerce, testifying in support of House Bill 1487. You should also have the Maryland Entertainment Council's testimony support in the bill file. This bill renames the Maryland Entertainment Council as the new Maryland Entertainment Industry Council and adds some new members. This council was established through legislation in 2023 with an interim report due in 2024 and a final report due in September 2024 and a sunset date by which the council was to have completed its work of June 30th, 2025. However, due to the strikes and labor negotiations in the entertainment industry last year, the body was not able to begin its work in earnest until early 2024. This does not leave enough time for the council to truly serve its purpose and complete its work. House Bill 1487 formally codifies the council within the Department of Commerce, eliminates the sunset, and adds the words industry to its name to avoid confusion with other councils. It also expands membership to include the Secretaries of Commerce, Housing and Community Development, and Labor or their designees. Film, TV, and other entertainment productions creates jobs, generate revenue, and raise the profile of our great state. This council has an important role in making sure that Maryland is competitive and that we attract more of these productions in the future. Circumstances in Hollywood may have kept the council from getting the work the way we'd hoped last year, but now we're all systems go, so to speak. I do want to note the bill was amended in the House to clarify annual reporting requirements, and Commerce is in agreement with that amendment. We urge a favorable report on HB 1487, and I'm happy to answer any questions you may have. Thank you, Madam Chair.
Thank you, Mr. Secretary. I don't see any questions and no opposition.
There you go.
Thank you for your testimony.
Thank you so much. Thank you.
That ends the hearing on House Bill 1487. And our last bill of the day is a full bill hearing because there is opposition. It's House Bill 1388, Labor and Employment, Non-Compete and Conflict of Interest Clauses, Veterinary and Healthcare Professionals. And Delegate Terry Hill will present the bill for us.
There, panel.
Wherever you'd like,
All right.
wherever you're comfortable,
Thank you,
Delegate.
Madam Chair. It's good to see you in this position.
You have a panel?
Yes.
You can bring up your panel, please.
Come on up. All right.
That's it. Steve Wise is your
I thought
panel.
I had other
Not
folks
much of a
here.
panel.
I know, but he's one of the best. Let me see. I thought I had a group of panelists here. Let me see.
I think they're.
Yeah, there we go. All right. That looks more like a good time. You want to say? Okay. All right. Thank you, Madam Chair. It's a privilege and a pleasure to be here this afternoon to present HB 1388, Labor and Employment Non-Compete Agreements, et cetera. So, essentially a non-compete agreement is a contractual agreement that forbids a person who's leaving employment either of their own volition before the contract otherwise would be gone, or they're fired from either being employed or setting up a self-employment opportunity in a similar field within a geographic area for a period of time. And the state of Maryland, a couple of years ago, found that it was not in the best interest of the state to allow these non-compete agreements to occur, particularly for people who are making within, I think our law says 150% of the poverty line. But we were silent on above that. What this bill does is it says in the areas of veterinary medicine and medicine healthcare generally, where we have significant workforce shortages, that it is also not in the interest of the state for these non-compete agreements to be in effect. There's a lot of information in your folder, including our article from NBC News that talks about the prevalence of non-compete agreements, particularly in the healthcare industry, and how detrimental they are. And they have become more and more popular as hospital and these large corporate entities have begun purchasing medical practices. And they're really coercive in nature. And I think that you can look at this through three lenses. You can look at it from an employer standpoint, and you've got some opposing testimony about how they feel that they would be negatively impacted. You can look at it from the employee standpoint, and you can look at it from a patient or client standpoint. And as a legislator, I think it's my responsibility, and I think that the people on this committee would also feel that our primary obligation are to the citizens of the state. And it is through that lens that I ask that you look at the role of the non-competes. So when we have situations where physicians or veterinarians, for that matter, have established relationships with their patients, trusted relationships, and then when they leave employment, often through no desire of their own, and they want to continue those relationships, or at least be available to continue those relationships, they're forbidden from doing so. That means that the patients are then stuck trying to find another provider. And I know as a physician that over the years, I've had a number of patients who have come to me and complained that some doctor with whom they had a relationship seemed to have left in the middle of the night. And you've maybe known people who've had that same complaint. They just didn't know what happened. And I came to find out later that in most of those cases, the people left in the middle of the night because they had non-compete agreements. And they had no legal right under that contract to stay. So then you have patients trying to establish a new relationship, often with no information. It's different, you know, when I change when my hairdresser leaves a beautician shop and I go there and I want to find out where she's gone and they don't want to give me the information, that's one thing. But when a physician is uprooted and has to move their family out, and they're not allowed to open up a practice or in any way establish and at least attempt to reestablish, that becomes a problem. That being said, there's nothing about this bill that prevents other contractual clauses such as who owns the patient list. Under this legislation, absolutely, the employer will continue to own the patient list. Under this legislation, the employer would continue to be able to require clawbacks. So if they put investments into recruiting the practitioner and they feel they're going to lose that, they can reclaim those clawbacks. So I think that this is pretty straightforward. It just simply says that you can't prohibit a practitioner from practicing in the same geographic area. It doesn't affect markets, because if the markets were sufficient for the practitioner to work under your employee, then the market is still there if they're not working under your employee. And then I'll say a final thing, because I know we want to keep this short. There is Western Maryland UPMC in their opposition testimony list the neighboring medical centers, and they give an example of a general surgeon and what would happen if the general surgeon they employed left. And they make the point that they had the closest institutions are 60, 65, 70, 75 miles away. And I think they actually make our argument. If there's a general surgeon under their employee who leaves, who would like to set up practice in that community, their non-compete means that all those patients who need that general surgeon would now have to travel 60 to 75 miles to find one, because they are forbidden that surgeon from practicing. A general surgeon needs a hospital. So even if it's no longer, that person is no longer under that hospital's employ, that person would still likely have privileges at that hospital. So what we're really talking about are the coercive forces of the hospital system, not to keep someone in the area for the patients, but to make sure that they're controlling that person. So again, I'd ask you to lean in favor of patients and make sure that patients have access to the care that they need by finding that these non-compete agreements are not consistent with the goals and values of the state. Thank you.
Thank you, Delegate. We'll ask questions at the end of the panel. So who would like to go next?
I'll be happy to go, Madam Chair. Steve Wise here today on behalf of the MedChi, family physicians and some other physician groups which are pointed out on our letter. A few things for the committee to think about as it weighs this bill, which we strongly support. And the first is, we don't ask you to set this as a public policy lightly. We recognize that it asks the General Assembly to get in between two parties who otherwise would be free to enter a contract. But why do we ask you to do it in this case? Because it is more than just those two parties that are affected by the contract. Once you have a physician employed at a hospital and they are seeing patients, if that relationship comes to an end and the physician is forced to leave and go X distance for X amount of time, there's a third party affected by that, and it's the patient. And we don't think that should be the case. To illustrate why this is an issue now, and it hasn't been as much in the past, I'll give you this statistic. For family physicians, approximately 73% of them are now employed, meaning they work for hospital, other employer, and in some cases their practices are owned by outside third-party entities. That number among younger family physicians is closer to 90%. It didn't used to be that way, but the trend is in that direction. So these types of agreements and these types of clauses are more prevalent. The final thing I'll mention is there is a Federal Trade Commission rule pending on this, which would ban non-compete clauses. And you might say, well, let's let them do it, and then we don't have potentially different rules here. The key exception to that rule is that it does not apply to nonprofit entities. And as you may know, most, if not all of our hospitals are nonprofit entities. So for those reasons, we'd ask you to support the bill. Thank you.
Thank you. Who's next?
Madam Chair and distinguished senators, thank you for the opportunity to testify today in strong support of this bill. My name is CJ Cornelia, and I'm one of 4 boarded large animal surgeons in the state. I was the only surgeon that saw emergency surgeries, and currently my hands are tied with a non-compete. This means there's no place in the entire state to receive this care right now, and animal owners are having to drive to Virginia or Pennsylvania to get services. This is just one pertinent example of how even just one non-compete can completely wipe out access to care, especially considering specialty care. I'd like to highlight how non-competes can jeopardize patient care. I've been in situations where a veterinary practice owner, through negligence and malpractice, has directly caused complications and patient suffering. I've had to console animal owners as they've asked me, why did their pet die because of these actions? But with a non-compete, there's fear of retaliation and termination for speaking up to correct these issues. And this has put myself and many others in the impossible ethical dilemma of providing for our family and upholding the oath to our profession. A whistleblower protection doesn't mean that your non-compete is going to be not enforced. And that's why we need you. We need the legislature to prohibit them. Your doctor may be in this situation right now, and your pet's care or your personal care could be negatively impacted. And finally, many other states have already done this or are moving towards doing this in healthcare. 70% of surgeons in one study said they actively look for a job that has no non-compete. Many national veterinary corporations are using this as a recruitment tool, no non-compete, to recruit vets. If we pass this law, people will want to come to the state, and then doctors and providers won't be forced to leave the state if they choose to change where they work. This is a win for all of Marylanders. Thank you.
Hello, thank you for the opportunity to testify in support of this bill. My name is Dana Lunas Blumel. I was born and raised in Annapolis, and I own and run a horse farm in Davidsonville. And unlike me, I hope none of you have gotten a phone call at 6 p.m. on a Friday night with a cancer diagnosis. 2 years ago, I got that call, and through many references, through family, through the head of the of the imaging center, I got a recommendation to an amazing oncologist. And what I didn't realize was that she was now an hour west of my property and an hour and a half from her own treatment center. She was going through a battle of non-compete with the non-compete clause with the hospital that they left because of subpar care for their patients. I was in uncharted territory with my own health and have always been extremely healthy. I knew I needed somebody to navigate this with me and to be my quarterback in my cancer treatments. When I started chemo, my doctor couldn't be there. She couldn't be there because of the non-compete. I had to drive an hour and a half one way to see her and an hour back for treatment. And many patients had lots of problems with their chemo treatments, and there were no doctors available. There was just the nurses communicating with the doctors via phone. I'm now in a similar non-compete issue with my large animal veterinarian. Owning the farm in Davidsonville, I'm also responsible for other people's large animals, and I have no emergency care at this time. I travel over an hour and a half to see my veterinarian when possible, but as we know, large animals and small animals, they sometimes need quicker care than loading them in a trailer and taking them an hour and a half away. I do hope that you understand that in emergencies, whether they are four-legged or two-legged, that patients should come first. And I really truly hope that you are in favor of this bill and will vote on behalf of all patients and not profits, whether they're two or four-legged patients. Thank you.
Good afternoon, Robin Elliott. I'm here today on behalf of the Maryland Nurses Association, the Maryland Academy of Physician Assistants, the professional counselors, and the nurse midwives. all the conversation I had with those 4 clients was completely focused on the disruption of continuity of care if a practitioner in switching jobs for whatever reason needs to relocate where they practice, potentially even over state lines. With something like nurse midwives relationship with the patient or professional counselors that has worked for a very long time to develop that therapeutically mutual relationship. This can be very disruptive. And so we would ask for your consideration of this bill. Thank you so much.
Thank you. I think everyone on the panel has spoken. Senators, you have questions?
We have 2 on Zoom also.
As part of this panel? Okay, we'll do that. Who are the 2 on Zoom?
Yes, Carol Tweed and Evan Starr. Carol Tweed and Evan Starr.
Okay, are they on? Okay. Thank you, Delegate.
Sorry
They
about that.
weren't actually signed up as your panel. They're
Oh, I
just
see.
listed.
My error.
Not a problem. We'll get it taken care of. Because Tammy's amazing. Okay, is this Carol Tweed?
Hi.
Mr. Hi. Carol, you want to start on mute and do your testimony? You have 2 minutes. Thank you.
Thank you. Hi, thanks for allowing me to join you today. I'm Carol Tweed. I'm an oncologist and hematologist for Maryland Oncology Hematology in Annapolis and in Easton. In 2012, I moved to Annapolis to join an esteemed oncology group employed at the time by Anne Arundel Medical Center. I'm here to support House Bill 1388. In 2020, 8 years after joining the local hospital, after having requested meetings with administration over concerns regarding patient safety and patient quality of care, we were terminated, all 9 of the oncologists. We were served with letters advising us of the hospital's plan to enforce a restrictive covenant or non-compete, as well as their efforts plan to prevent solicitation of patients, which largely just meant we could not tell our patients where we were going. And acutely, our patients were affected. This bill, as already stated, above all else, is about the patient experience. This is the experience of frightened and medically complex patients who are struggling to preserve their life. They lose their anchor suddenly when these events happen. That anchor is the physician who knows their goals, who knows their complex history, who knows their family. Suddenly, they can't find their own doctor. There's the patient who showed up at my doorstep in Davidsonville with candy for my children, apologizing for interrupting our family time because they couldn't find where I practiced and they were scared to lose me. There's the patient who died in Anne Arundel Medical Center, a young woman with metastatic breast cancer who I had treated for years. But at the time when I was supposed to be there palliating her and holding her hand, I was unable and not allowed to be there. All of those promises were wiped away. There's the patient who's getting weekly chemo, who's driving 2 hours on the Beltway, sick and tired just to see me. There's more to say, but the most important thing to say is that non-competes eradicate patient choice. They eradicate patient quality of care and eradicate patient safety. This is about patients and not business. Thank you.
Thank you, Dr. Tweed. And Evan Starr. There we go.
Thank you so much. My name is Evan Starr. I'm an associate professor at the University of Maryland at the Robert H. Smith School of Business, and I've been studying non-compete agreements for the last decade or so. I've testified on non-competes in front of the U.S. Senate, the U.S. House, and various state legislatures, and I've written more than a dozen papers on non-competes. My research has been about how common they are, how they affect workers, how they affect firms, and the effects of various regulatory approaches. And what I want to talk about today is what might happen if a ban like this comes into play. Bans on non-competes for physicians have been very common in the last few years. Indeed, they started in the late 1970s and 80s when several states realized that patients could be hurt by a physician's non-compete agreement. And so if you study what happens after these bans come into play, you find that, hospitals and doctors' offices are actually better off. We see more of them, and they actually make it easier to hire, and all those institutions actually grow. And so if you look at some of the opposing testimony in this case, you'll find the Hospital Association, for example, saying that we need non-competes because we have trouble hiring. And I think that's part of a collective action problem. which is that if every hospital system uses non-compete agreements, then it is very hard to hire. And the only way to solve that problem is actually to get rid of non-compete agreements. And then when you do so, you actually make it a lot easier to fill all of those hiring needs. Physicians and veterinarians can stay local to all of their constituents if they find a better place that that suits their needs. And so I think that, you know, when you're thinking about non-compete agreements in this particular policy, and you're looking at the arguments made by the Hospital Association, it's really important to think about what's going to be the effect of this policy. And then second, what are the other tools that these firms have to still protect their legitimate interests? They can still use agreements not to solicit. They can still use confidentiality agreements. It is just the non-compete, which is going to say that they can now go join or start another company in their same industry in their local area. And so, you know, I would urge you to look at the evidence and how passing this bill would likely affect all of the constituents. Thank you.
Thank you. So if both of you will stay on, we have a in-person panel. I'm going to see if there's any questions, starting with Senator Reedy.
Thank you, Madam Chair. And I wonder if I could, I know we want generally to have one person answer a question. Maybe I might, Steve, if I could ask you, just representing MedChi today. I'm of two minds of this bill. As this is the first time we've heard it. Are there other places in industry where we ban non-competes? Are we asking for something, or is this bill asking for something unique, or? You heard testimony that other states have taken this action with health occupations, but I can tell you, in my world, the attorney world, they are prohibited. And the basis of that is very similar to what you have in front of you here, which is the attorney-client privilege is basically, supposed to be sort of sacred. The sanctity of that is the basis of the rule prohibiting non-competes among attorneys. And, as an attorney who's represented doctors for a long period of time, it kind of strikes me as odd, to say the least, that the patient doctor privilege or the provider patient privilege is not similarly treated under the law, because in many ways you're sharing a lot more personal things with your provider than you are with your attorney at times. Are there other areas where Maryland has gotten into non-competes? Maryland, well, let me rephrase, where Maryland state law has forbid or limited non-competes that you're aware of? Actually, if you look in the text of the bill, you'll see that the legislature stepped in just a few years ago for occupations that are below a certain wage level. Yes, that's right. There's a limit on wage. And prohibited those, and that's actually existing law, but you can see it in the bill. Okay. Okay. And then have we seen, well, I guess another question, the other question that I had was, have we seen where other states that have gotten rid of non-competes have had better opportunity on health occupations and I could let someone else answer if they'd like to. I think Mr. Starr, that might be in his wheelhouse. Mr. Starr, could you just answer that question about what's going on in other states relative to, you spoke very definitively about how if they just get rid of non-competes, that the problem would maybe not go away, would be, I mean, what's the data on that?
Yeah, so if we have a study where we look at some of the earliest bans on non-competes for physicians in the healthcare context, and we look at what happens to employment at the healthcare establishments and the number of healthcare establishments. And if you compare states that ban non-competes for physicians versus those that didn't ban non-competes for physicians, our findings suggest that the number of practices rises by about 4%. Practice employment begins to increase. These medical establishments begin to grow, and the survival rate actually rises. So these companies are more likely to survive than they otherwise would.
Okay, Madam Chair, just in maybe it isn't that so. My concern with this, I really feel like I see both sides here. My concern is getting involved at the level where we're telling health providers what they can and can't do in negotiations with potential workforce. And also, though, I understand that you get in these situations where, because it becomes standard practice to do these non-competes, perhaps, then you have this unintended consequence of keeping, like in the veterinary space, what's been testified to. So, I mean, that's not a question. That's what I'm wrestling with, but I appreciate the testimony and the answers. That this is the first time we've really seen this issue, Madam Chair. So I think you would acknowledge, Delegate, would you acknowledge this is a significant change in healthcare policy, or would you say this is a modest change in how we're viewing healthcare policy?
I think it's a significant change towards increasing patient access to care, which as a member of HGO, where we were colleagues, is a high priority of the state. And I think, again, we've discussed how the face of practicing medicine and medical care has changed over time with more and more large institutions and less competition in those areas as well, even in practices. So as a solo practitioner, I've hired associates, no non-compete. And when they left, we had an issue about them trying to take charts, and we just said, that's not in your contract. And the charts were returned. And we continue to have a very actually collaborative relationship over many, many years. And it's always nice to have a colleague that you can call on sometimes. Okay. So I don't see the negative. I've read the arguments. We sat through the House hearing, and I think that again, it's not the employer who should be the priority. And I actually think most employers find that that this is not as onerous on them as they think. I think they're used to using coercive methods to try and keep people in place. And it's not necessary.
Thank you.
Thank you. And Senator Mounts?
No, thank you, Madam Chair. I need some help. The witness on the virtual witness, bottom left corner, I didn't get the name.
One is Dr. Tweed and the other is Mr. Evan Starr.
Dr. Tweed. Dr. Tweed, I couldn't hear your testimony. Did you say that you started in Easton?
Oh, I'm sorry. No, I practice currently in Annapolis. We also have a practice in Easton. My practice in 2020, from which I was terminated, was the Anne Arundel Medical Center Employed Oncology Group in Annapolis.
Okay. So I heard Easton and my ears perked up. That's in my district. So of course I wanted to make sure I knew.
We now are in Easton, actually.
Thank you. And then I want to follow up with one other question to Mr. Wise. And in listening to this and trying to understand what's happening, as far as non-compete goes and the practice of medicine and practitioners, and I've had some conversations with doctors that are basically leaving. They're leaving the state of Maryland. And it wasn't about non-compete, it was about compensation. Is the issue compensation or is it non-compete? How would you kind of ferret that out? Because, when you talk about other states, they're not under the same reimbursement plan that Maryland is. And the doctors that will complain will tell you that the answer is always, it's a higher, whoever they're talking to will respond with, well, that question's above my pay grade. We can't fix that problem right now. And is it, to what degree does the compensation levels of what's going on in healthcare right now, how is that driving this discussion when we're talking about non-compete and whether, if you do get rid of non-competes and you still, is your reimbursement any better if you leave the hospital system and go on your own? Or how does that work?
So that's a question that touches on a lot of areas, but I'll try to summarize it. I don't want to underestimate the payment issue. I mean, Maryland is at the lower end of that, unfortunately, when it comes to private payers.
Which is a problem.
It's a problem. But it is not the only problem. As you know, we have a pretty unique system with our hospitals as well. And I think what you find are practices willing to be bought out or become employed because they are in a very almost unsustainable situation when they're on their own. And they have a hospital that comes in and is willing to buy their practice and offload some of the things that, frankly, the practices are not paid for, like billing issues, prior authorization, things this committee is very familiar with. And that suddenly, makes the world sustainable, not great necessarily, but sustainable compared to where they are at the time in a private practice. All of which leads to this problem, which is more and more physicians are employed as a result of that. And employment is almost one and the same as signing a non-compete anymore.
So how do we know if there's a non-compete, if the non-compete is eliminated, how do we know those doctors stay? How do we know that we are maintaining access to care? And I can
So-
kind of move that to Dr. Hill, because she,
Okay, thank you, Senator. It's my first time being with you as Senator. Good to see you,
yeah.
sir. So what we know is that what these employers giving testimony are complaining about is that they don't want the competition. The non-compete says, I don't want these doctors practicing in the area unless they work for me. So that's the answer to your question. How do we know the doctors want to stay? Because they want to stay. And that's what the employers are saying they don't want. They want them in the area as long as they can control them. They don't want them if they're going to be independently speaking up for patients. We have, I will tell you of a personal situation, one of the hospitals that I attend at, where they just lost a whole team of cardiologists because the cardiologist didn't like the bottom line approach to patient care that the administration was starting to enforce. And when they spoke up, they said, we'll get rid of all you. We just heard the same thing from Dr. Tweed. So what they're, and what these physicians are saying is, I'm here for the patient. My family moved here, we lived here, we grew up here. We're established. So that's okay. If you're not going to employ me, then I will go back as much as I'd like to be employed for all the reasons that Mr. Weiss talked about. I'm going to stand up for the way I need to practice medicine for my patient's sake. And so I'm going to either join a small group or start out on my own or do something else. And what these hospitals and other employers are saying, you can't be in the neighborhood. You can't be around here where the patients can find you because we're afraid that the patients will choose you over the institution.
Thank you. I appreciate that because I was putting that in the context of our district, which is a rural district. We have a hospital in Salisbury. We have a hospital in Easton, and we've got a regional hub and spoke for the shore. And then we have the neighboring Delaware hospitals and of course, Baltimore.
Right.
But that's a perspective that's helpful to me. So
And it
thank
would
you.
actually help the rural communities because the doctors actually would like to stay. But when they're prevented from doing so, and it's not just the doctors, it's the other, all the way, we've got nurses who leave a practice, have an opportunity, or told you can't be a nurse in this area. And it really is coercive. It's designed to make sure that they stay even when the employment situation is not the best that it could be.
Understood. Thank you.
I started to say Dr. Hill, I guess Dr. Delegate Hill. So in the example they just gave of the cardiac practice, so what happens to them? They left the hospital or the hospital fired them?
Yeah.
And then-
So, and we've had, there've been a number of cases of that. So in that case, they moved however miles away and had to affiliate with somewhere else, and they might have wanted to stay in their office or in the area, maybe even get privileges at the hospital, but not as an employee. We had a situation at another hospital that I attend at where they lost their entire radiology group and had to.
So a non-compete clause has a certain number of years after you leave a practice?
Geographic distance and a certain number of years.
And is it usually like 2 years? I've heard 2 years.
Generally, we talk about, some amount of distance. Maybe it's 5 miles, maybe it's 30 miles, maybe it's 60 miles for 2 years. They used to be longer. The courts have been pretty clear that that if a non-compete is overly aggressive, that they've been finding that those cannot stand. The problem is that requires everyone to go to court. And we can't have, it's easier to just leave and start new, go to West Virginia, go to Delaware, than to stay and fight. And
Well-
we're talking about providers who would prefer to stay.
Thank you. My question is actually for our veterinarian on the panel, because I've heard from a couple large animal veterinarians. So apparently we have a real shortage in Maryland of large animal veterinarians. So you are now not allowed to practice large animal surgery at all in Maryland?
My particular non-compete radius is 30 miles as the crow flies, which in Maryland presents some geographic challenges with the bodies of water. And in order to be able to provide those services, emergency services, I need to live close to where I'm providing those services. So I still practice within the state, but I am driving 2 hours, each way for calls. I can't provide those emergency services that the state currently lacks due to that non-compete agreement.
Okay, so yours was about distance.
2 years and 30 miles
2 years
is
and
what
30
it
miles. I just
currently
want-
stands.
I had to work under non-compete for my entire career. And so I understand what a non-compete is. I just trying to figure out what are the details of your profession and medical profession, but it doesn't sound like it's anything, it's not typical. It changes depending on the non-compete agreement.
The individual terms obviously would be different. I would say in the veterinary profession, though, non-competes are, especially large animal, are very, very pervasive. You almost cannot get a job without taking one. And then often with the specific large animal problem, our non-competes typically don't preclude a pharmacy job or an industry job or going to small animal medicine. So we have large animal providers, they work for a year or two, they decide to leave a practice. This non-compete is enforced against them. So then they decide move or transition careers. They transition careers. We never get those providers back. We have a serious large animal veterinary shortage in the whole country, and this is a big player of it.
Thank you very much. Do I have any other questions from any other senators? I don't see any questions for this panel. That ends this panel, but we're going to continue the hearing.
Thank you.
Thank you. Thank you very much. So I have Brittany Caniglia, Sharon Caniglia, Delois Noble Strong, Lorraine DiLorenzo. Just come up and take a seat, and when we have 6 seats filled, I'll stop. Brett Langinger. Shelley Garrett. Dr. Jennifer Kruger. Jennifer Dawson. Okay, just about filled. One more seat open. Wendy Lott. Thank you. So we're going to start on the end. Are you Dr. Kruger? No,
Shelley
right.
Garrett.
Shelley. Okay, we're going to start with you and everyone right down the line. You each have 2 minutes, and at the end of the panel, we'll have questions. Thank you.
Good afternoon, Senator Bidel and Senate Finance Committee members. I am the Agriculture Business Development Director for the Anne Arundel Economic Development Corporation. I speak in support of House Bill 1388 for both my department and County Executive Stuart Pittman, who has also submitted written testimony to you today. And I thank you for the opportunity to speak before you. Agriculture is Maryland's largest commercial industry, contributing over $8 billion annually to the economy. There are over 94,000 horses in Maryland with a $2.9 billion contribution to the economy. Nearly 5,000 of those horses and only 6 equine veterinarians reside within Anne Arundel County. 2 of those vets are banned from practicing within the county due to non-competes. The removal of accessibility to these vet services forces owners to transport sick or injured horses outside of the radius. In the case of emergencies, the closest surgical centers are Virginia and Pennsylvania. This adds unnecessary stress to the animal, and the delay in treatment jeopardizes positive outcomes. Sasha Hill, an inspiring equine veterinarian, has submitted written testimony to you as well about her inability to gain field experience due to a non-compete. Ms. Hill previously traveled with one of those veterinarians, and now due to scheduling, she is no longer able to travel with them and also still stay successful and thrive in her education. A national shortage of 15,000 veterinarians is expected by 2025. Only 1.5% of those veterinarians are going to graduate and enter equine medicine. 50% of those will leave their path within 5 years. And the allowance of non-competes prevent our youth from obtaining experience and education. Maryland agriculture needs veterinarians, not non-competes. The question has been posed on the viability of current businesses should this bill pass. Those same businesses offer the solution. The inaccessibility is to buy out the non-compete, further demonstrating that veterinary non-competes are for profits and not animal welfare. Those businesses will still exist should their business models and standards of care meet owner expectations of do no harm. Non-competes bind unknowing third parties to the contract. We ask that the Senate Finance Committee give this bill a favorable vote for the good of the public, agriculture of Maryland, and the furtherance of education, and most importantly, the animals. Thank you for your consideration.
Good afternoon. My name is Dr. Jenny Kruger. I'm a small animal veterinarian practicing in Montgomery County, Maryland, specifically in Olney, where I've lived the majority of my life. I serve as one of the 2 delegates for the state of Maryland to the AVMA, the American Veterinary Medical Association, and in this role, I also serve as a board member for the Maryland Veterinary Medical Association. I'm here requesting your support in eliminating non-competes in Maryland. They're antiquated, have far-reaching negative consequences in the veterinary profession, and adversely affect the public interest. I've been practicing veterinary medicine for nearly 16 years. Around 10 years ago, I naively signed a contract with my most recent employer containing a 10-mile non-compete clause. It has hovered like a dark cloud over my head for the last 10 years. Unfortunately, a continuous negative culture enveloped this practice, manifested by the owners, that trickled down to affect myself, other veterinarians, and many of the support staff. I grew up in Olney, have an extensive friend and family network here, the majority of which are clients of mine. I have close relationships with these clients who trust me deeply to care for them and their pets. Having to consider options 10+ miles away places undue strain on these trusted clients to have to travel to see me when they still want me to care for their beloved animal companions. Myself, like many others faced with feeling trapped in subpar and detrimental conditions, I was one of the statistics that reached the lowest of lows in our profession. 7 years ago, when my second child was only several months old, I hit rock bottom in my mental health. One night out of the blue, I had a debilitating panic attack that sent me to the emergency room. It took several mental health professionals to tamper the panic attacks that continued for months, down to a level where I could function professionally and personally. It's taken years of therapy and the eventual addition of medication to regain control of my mental health and physical health that suffered. Years of working in that negative culture of the practice, with the inability to take another job in or very near my hometown to be close to my children, there in my support network of family and friends, and the clients that rely on me, contributed largely to my mental health crisis. Having recently departed from this practice, I'm feeling the heavy weight of the non-compete even more. Ultimately has meant I'm giving heavy consideration to leaving this corner of the profession, which is already suffering a significant shortage. Maryland needs to follow suit, as many other states have already done, and do what's in the best interest of the veterinarian, our profession, and the public interest. Thank you.
Madam Chair and the members of the committee, my name is Wendy Lott. My name is Wendy Lott. I own a horse farm in Lothian, Maryland. On the evening of May 22nd, 2023, one of the horses on my farm had an emergency. I called out a local veterinarian who had a good relationship with at the time, and she refused to come out for the emergency. She also refused to send out her associates, which left us scrambling to find a vet to come out. Once we finally got somebody out, thank God the horse is okay. This same veterinarian is now preventing care at my farm from other veterinarians to come and see my horses. I shouldn't have somebody telling me who I can and can't use for care for my animals. That hinders their care dramatically. If I have to have an emergency surgery or anything like that, I have to drive to Pennsylvania or Virginia to get help. That's not fair. This same veterinarian who refused to come out to my farm put in a Christmas newsletter a few weeks ago, or a few months ago. It was a Christmas newsletter. I warned readers about the threat of equine veterinary shortages that was on the horizon. I promised in that newsletter that we would see these shortages in our lifetime to be theatrical. And here we are, here I am, one horse vet power. Being my associate did not drive these people from seeing horses. These beautiful people studied all about horses and love horses, and some were truly fantastic equine practitioners. Yet other forces drove them to make their own heart-wrenching and difficult decision to change species of specialty or to leave the veterinary profession entirely. What this practice owner is not telling you is she holds non-competes against all of her veterinarians that come to her practice. There have been 15 veterinarians, at least 15, that have gone to her practice and have left for one reason or another. She drives them away, not allowing them to stay in Maryland, not allowing them to stay and do what they want to do. Okay, which also deprives horses in the local community access to care. She doesn't offer surgeries or anything like that, so we don't have a local equine surgeon. Okay, this situation is all too common in the veterinary profession. Practice owners impose non-competes. Talented vets force them out of the profession and then complain that there's no vets to work.
Please wrap up.
Please pass HB 1388.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Brett Leininger here today in support of House Bill 1388 on behalf of the Maryland Association of Nurse Anesthetists. The bill would improve access to care, quality, and affordability of care, as has been mentioned. Have a real example of something fairly recent in another state. I was asked about other states. Starting in 2015, there was a private equity backed anesthesia group that began purchasing practices in the Denver metro area. And it was modeled on a plan and a similar approach the company took in another state. I think it was Texas earlier in the decade. By 2021, that entity bought out all of its major competitors and established control of the surgical anesthesia at the two largest hospital systems in the Denver area, accounting for more than 70% of the health plan reimbursements. The result of the successful cornering of that of the Denver area market was higher costs for consumers and their employer provided plans. Onerous non-compete restrictions on the healthcare professionals and patients, often facing delays and outright cancellations of the surgeries. At the same time, rates went higher, significantly higher. Just about a month ago to this day, the Attorney General in Colorado announced an agreement with that group that would completely end their non-competes within 18 months of the agreement taking effect. So there's a real case in point that has happened very recently. And with that, we support the legislation.
Thank you. Good afternoon, honorable senators. My name is Dr. Brittany Williamson. I'm a horse veterinarian specializing in sports medicine and rehabilitation. I'm here to support House Bill 1388 and share my personal experience. In 2019, I joined a practice in Southern Maryland, and it was my express intent to make this practice my forever home. I brought my current clients and patients to the practice, and my reputation brought others throughout my employment. However, over time, it was clear that I did not share the same views on business, patient care, or ethics of this practice. As the business owner's desire and ability to practice decreased, I saw the costs of medication rise to make up an easy dollar. Medications were frequently marked up 500 to 600%, making them unaffordable for the average owner and sacrificing patient care. The business had multiple health and radiation code violations, and the owner repeatedly deceived government organizations about these violations. The practice owned and operated 5 X-ray generators, which should have been inspected and calibrated annually by Maryland regulations. However, 4 of the 5 of these never were. 6 months after I joined the practice, I suffered an early miscarriage, and I was not alone in this situation. I drove a colleague to the emergency room as she cried and bled through her clothes in her early miscarriage, and I mourned the loss of an otherwise healthy 16-week pregnancy with another coworker. In the 4 years I was employed there, no less than 50% of all pregnancies ended in miscarriage. I cannot say for certain that a direct cause and effect was at play, but I do know that radiation exposure has been a proven risk factor for pregnancy loss. However, with a non-compete clause waived in front of me as leverage, I had no power to advocate for better working conditions. These, among other things, ultimately led me to leave the practice and start my own business outside the radius. I firmly believe non-compete clauses absolve business owners from accountability to their employees and prevent providers from advocating for better patient care and better working environments. I also firmly believe that patients are not assets to be owned and sold. A patient or animal owner should have the right to choose the provider that best suits their needs. Thank you.
Good afternoon, Senators. My name is Sharon Cornelia. I'm retired from 44 years in education as a teacher and an administrator. I'm here to ask for your support of House Bill 1388 to prohibit non-competes agreements in healthcare and veterinary professions. I was hospitalized in the emergency room in 2020 for a diabetic crisis. I have a tremendous fear of doctors and was reluctant to seek regular care. However, I finally found a primary care physician that I have grown to trust and who has diligently managed my health care for the past several years. After learning of this issue, I am terrified that I could lose access to my doctor because of a non-compete agreement. Multiple studies include one published in the Journal of American Medical Association of Internal Medicine have shown that increased continuity of care with the same doctor reduces my chances of ending up in the emergency room again. I'd like to highlight another study that was published in the American Journal of Managed Care. This study found that patients with diabetes who have consistent doctor-patient relationships with the same doctor have a lower mortality rate of 4% compared to those who saw different doctors at 12%. Please don't let a non-compete agreement make myself or many other patients with diabetes 3 times more likely to die. This is just one example of how non-competes can jeopardize care. This also applies to every doctor-patient relationship in human and in veterinary health care. This bill is about the constituents of Maryland and our animals. The patients are more important than the corporate financial interests. I ask this committee for a favorable report and vote on this bill. Thank you.
Thank you. Senators, do I have any questions? I do. Senator Reedy for this panel.
Thank you, Madam Chair. Can I ask, maybe on the end here, because I all of you had very interesting testimony in it, and what do we do about the situation when we talk about non-competes? You have veterinary practices, or in some cases hospitals or other types of medical practices. The reason they're doing non-competes, at least originally, and I recognize some of you are talking about people who maybe are bad actors in the situation, so I'm not trying to absolve anybody of anything bad that's happened, but they've made significant investments into a practice. And so the non-compete is a way of protecting that investment. Now, I do know there's other ways that a doctor could, somebody who has a practice could have other types of protections. But if that's the case, then that patient still isn't going to be able to use your services because you're not allowed to contact them if you left. So can you talk about, like, how do we balance this? Because you would still have issues where there wouldn't be continuity of care even without non-competes.
Sure, I can do my best to answer that on there. So what I am seeing more of is that it's the non-compete in itself does not protect that on there. So there are other avenues, as you spoke to, that would be a reimbursement contract, would be, say, as a hospital, I invested in for you to relocate to my area. I invested in additional education for you, specialty work, those types of educational things, that in the end that you would, if you left within a certain time period, you would have to reimburse me for that amount to a certain percentage. A non-compete, all that does is just tie somebody to an area. And so if they were to leave that area or quit, be fired, whichever way, there is a definite non-continuity of practicing there and for healthcare for the patients, because now you are forced, you have to go out of that area. Where if I were to decide on my own, I no longer want to be here anymore, but I still want to be able to service my patients that I have a longstanding relationship with, I can now go and open a practice or join another practice instead. What I think non-competes effectively do in the economic side of it is just to keep them tied to that one hospital or that one business. It's not about the patient instead.
As a follow-up, you didn't have to sign a non-compete, correct, when you joined, or did you? I mean, is anybody forcing, is it standard practice across veteran? And I'll ask this person here just so we only want one person per question. So thank you for the answers. So do you have to sign a non-compete to be a vet to work in these practices?
They are at this time extremely pervasive. And both my husband and I have turned down other jobs because when we said, I'm sorry, we won't sign a non-compete, that was, they said no thank you to our employment. And I think the bottom line is, as vets and as doctors, we want to work. And in especially specialty care, we need hospitals to work out of. And so they don't prohibit people from working. They don't prohibit hospitals from hiring people and having good doctors. It just says, hey, there is some level of accountability. When I signed a contract, there was it had no end date per se. So things in the practice could change dramatically, and that non-compete never expired. I had no power to renegotiate my
How much,
contract.
not to interrupt you, but how
Yeah.
much, how long was the non-compete for?
It's also 2 years.
2 years. And then, okay, and what stops you from going and setting up your own veterinary practice instead of working for somebody is because you're in specialty, correct?
That's what I'm doing currently, but I have to drive over an hour from where I live to provide those services. Because it's a broad geographic radius. So I've taken that leap, but it's I can see fewer patients in a day because I have to drive fewer, which just further divides resources and care.
And the hospitals that will not, well, okay, thank you. It's interesting. Thank you very much.
It is interesting. Senator Ellis?
Yeah, yeah, thank you, Madam Chair, and thank you for your testimony. And I know Senator representing Charles County in Southern Maryland, we have a shortage of a lot of professional veterinary medical, and this bill and testimony just opened my eyes to one of the big reasons why we might have this shortage. So I appreciate this bill. Something piqued my interest. Someone here has talked about the equine industry. So it's like a $2 billion industry in Maryland. So if we have shortage of folks working in the industry, it seems like it will affect our economic productivity. But I'm curious, I'm not in that area. What generates that type of revenue around horses?
Sure. So around horses, it can be anything that is recreational, as well as that includes racehorse industry and betting off of there, as well as the feed stores, anything that goes towards the care of that animal as well in there. But mainly recreation and horse shows, boarding facilities, horse training, those types of industries.
Yeah, I didn't understand or know of that contribution from the horses. So thank you for sharing that. Thank you, Madam Chair.
Good. Any other questions from any senators? That ends this panel. Thank you very much. I'm going to go back and call some names that didn't respond just to make sure we didn't miss anybody. Delois Noble Strong, Lorraine DiVrienzo, Jennifer Dawson, and Sean Gandia. And this will be the last panel of favorables. In person, yeah, in person. Okay, I'll pick somebody else up. Okay, would you begin, please?
Hi, my name is Lorraine Dorenzo. I'm a Maryland horse owner in support of HB 1388. Last fall, I had a terrifying experience when my horse went into atrial fibrillation. Terrified as I was, thinking about what lay ahead, I was equally grateful to be navigating this diagnosis with an extraordinary vet who's cared for my horse for 5 years. But right as we were figuring out the next steps, the rug was completely pulled out from under me. My vet had to leave his current practice and could no longer treat my horse at our barn due to a non-compete clause. Continuity of care was shattered right when I needed it most. To deal with my horse's ongoing heart issue, I now have to transport him up to a hospital in Pennsylvania several hours away. I do not have a trailer, so not only do I have to take off an entire day of work and arrange after-school childcare, my barn manager also has to take off work to drive us there, adding hours of time and hundreds more dollars to an already expensive outing. What would have been $100 vet bill that our vet could accomplish in half an hour now takes 6 to 8 hours and is leaving, costs me at least 5 times that much. Money, I should mention, that is leaving the state on a regular basis at every barn affected by this non-compete. Even so, I know it could be worse. When another horse at our barn became ill and the non-compete prevented his longtime vet from coming out to our barn to provide emergency care, the owner was forced to put her horse on a trailer in agonizing pain and drive 2 hours through Beltway traffic to the nearest hospital in Virginia. Sadly, that horse died the next day. Who knows if he might have lived had the vet who knew him best been able to come out to our barn to treat him immediately. I feel completely lost not having my trusted vet follow up on my horse's ongoing health issue. I'm terrified that we will have a dire emergency of our own and won't be able to get someone out fast enough. Finding a local vet just to get routine care is getting harder and harder in Maryland. It can now take over a week to get a doctor out to see your horse, and appointments are regularly delayed for hours or rescheduled again and again because the only vet available is also on call for emergencies. Enforcing a non-compete against this backdrop makes zero sense. Thank you.
Hi, good afternoon. My name is Sean Gandia. I came knowledgeable of this issue when I went to work for the local veterinarian, and she basically held these two young veterinarians hostage. They brought in a lot of business. They created her practice, and she continually, I witnessed it personally, waved the non-compete in their face saying, "I have all the power, you cannot leave." And they had pretty much built the practice for her. So through researching this and following this bill through the House and testifying there, I had many of the same questions that you guys do. And I was shocked to hear that my doctor-patient relationship is also so much affected by this. Some of my research showed that in Massachusetts, that after they instituted the ban on non-competes, their actual ratio of doctor to patients in the behavioral health is now leading the nation. I believe it's, I don't know the exact number, I forgot. The major problem that I've seen is the businesses saying they lose their investment. To me, these are highly trained individuals that go to years and years and years of school, have licensures, have board certifications they have to maintain, have continuing education. I'm not sure what the investment as far as relocation and stuff, that seems normal. My question is, if these have to leave the practice for whatever reason, isn't the hospitals losing the investment anyway? And on top of that, all of the patients in the state are losing that investment and driving providers out of our area, especially veterinarians. So I would ask you for myself, please let me choose who my doctor is, who I want to see, who my veterinarian is, and protect my doctor-patient relationship. Thank you.
Thank you. I don't have any questions for this panel. I see no questions. Thank you both. We're gonna, let's do the two virtual favorables if we can. Joseph Marine and Sammy Sakira, stay on the subject for a minute here. If they're there. Not there? Okay. Thank you. Sammy, would you like to unmute and give us your testimony, please? You have 2 minutes.
Hi there. My name is Sammy Zakaria, and I've practiced cardiology in the state of Maryland since 2004. I'm the incoming governor of the Maryland chapter of the American College of Cardiology, which represents 610 cardiologists and a total of 1,146 cardiovascular professionals in the state of Maryland. We urge this committee for a favorable vote on this bill. 95% of our cardiologists support banning non-compete agreements because they interfere with the doctor or patient relationship, as been amply demonstrated earlier. In the last 15 years, there's been a huge shift in physician employment, and now 85% of cardiologists in the state of Maryland work for large corporations. Today, only a handful of institutions dominate healthcare in the Baltimore-Washington corridor, and only 1 or 2 corporations handle cardiac care in many Maryland counties. Should a cardiologist or a cardiac surgeon or advanced practice provider decide to change employers for whatever reason, a non-compete agreement could require that cardiologist be barred from working in the entire Baltimore-Washington area or entire sections of Western Maryland or on the Eastern Shore. I could share many cases of cardiologists and cardiac surgeons who have been forced to leave their state for neighboring states or elsewhere, decreasing access to care for their longstanding patients and increasing health disparities for our most vulnerable patients who are forced to travel longer distances to see their physicians. Our group's consensus is that non-compete clauses decrease access to care and harm the doctor-patient relationship. They stifle innovation, they increase costs on patients and physicians, and they increase physician burnout and cynicism. 12 states have already banned non-competes for physicians, including our neighboring state of Delaware. In addition, the Pennsylvania House Health Committee just passed similar legislation banning non-competes yesterday. And we've seen no significant detriments to banning non-compete agreements in those 12 states, and that healthcare institutions are thriving even more in many of those states. In summary, there's no societal or state benefits of physician non-compete agreements. This bill is critical. Please ban them in our states and bring back the centrality of the physician and patient relations. Thank you.
Thank you. Thank you, doctor. Do I have any questions for this doctor? I see no questions. Thank you for your testimony.
Thank you.
And do we have Joseph Maureen? Okay, we don't, we can always check that. So that ends the favorables, I think, unless Joseph appears. Next, we're going to have a panel of unfavorables. Neil Duke, Pegeen Townsend, Carrie Richard, William Regine, and Scott Conover. Let's start by the podium and just right down the line. Just pull the microphone close, please.
Good afternoon, Madam Chair, other members of the Senate Finance Committee. I want to thank you for affording me this opportunity to testify in opposition to House Bill 1388. My name is Neil Duke. I'm an attorney and I presently serve as the chair of the Labor and Employment Practice Group for the Johns Hopkins Health System. I've been practicing law now for 25 years, nearly all of which in the field of labor and employment law. I've also served a number of years as an adjunct faculty member at the University of Baltimore School of Law. During my many years of private practice, I guess what's germane to this particular conversation, I have represented and litigated on behalf of both companies attempting to enforce non-compete agreements, as well as individuals seeking to nullify the non-compete contracts that they executed with their employer. From a legal perspective, in Maryland, there's been a long and developed case law history with respect to non-compete agreements. The oldest such case that I've been able to find dates back to 1928, Durling versus City Baking Company, which ruled in favor of the concept of enforcing non-compete agreements. Since that time, Maryland courts have long served their role in upholding the standards of fairness and equity as it relates to non-compete agreements. Such agreements, as Madam Chair pointed out before, must be reasonable in geographic scope, duration of time, and necessary to protect legitimate business interests and constructed in such a way that it does not violate public policy. Further, Maryland courts have observed that non-competes are most applicable with respect to employees who offer unique services, much of which we've heard today, as well as to prevent the misuse of trade secrets and proprietary information. Finally, with respect to Maryland law and case history, Maryland courts have adopted a blue line approach with respect to non-compete agreements. In other words, agreements that are overbroad or otherwise do injustice to common law standards are subject to a judge's markups and revisions. But at its core, legitimate non-compete agreements are contracts entered into by sophisticated parties, often highly compensated and represented by counsel. I'll close with this. For all the reasons that will be stated by my esteemed colleagues on this panel, passage of this bill, at least in its current form, will not serve Maryland's best interests. There'll be the potential for disruption to business operations, destabilization of already established contractual relationships, and the very real possibility of the depression of wages as well. I will say this, I know it's been a difficult subject to tackle. I know the District of Columbia attempted to thread the needle with this by enforcing the
Your time's
provisions.
up. Thank you.
Understood, but thank you again for your time.
Who's next?
Good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to testify. My name is Scott Conover. I'm Vice President of the University of Maryland Physician Network, which oversees all of the employed physicians within the University of Maryland medical system hospitals. I'm a health attorney by trade and have practiced in Maryland for 28 years and worked for 3 different health systems and have negotiated literally hundreds and hundreds of physician employment agreements. And I'd like to start with the notion that, as mentioned earlier, these non-compete agreements are in fact highly negotiable. It's typically the first or second issue after compensation that providers come and talk to us about, including both the applicability of those non-competes in the event of termination, as well as the scope, the duration, and the applicability of the non-compete should that provider want to go back into private practice. In many instances over my career, I have granted exceptions in those negotiations to providers who wanted to go back into private practice in the local community. That benefits us as a hospital and it benefits the providers. I think what you're hearing here is actually the pernicious effects in many cases of for-profit entities like private equity that's come into this marketplace. And those private equity firms, and I'm just going to take a moment to digress because I do have concerns about their effect on healthcare, especially on nonprofit healthcare in Maryland. Those private equity firms do not provide charity care. They do not have the same incentives that all 48 nonprofit hospitals in this state have. Let's remember, those nonprofit hospitals are under a very different reimbursement system that obligate us to provide charity care for all comers. Private equity has no such obligation. In summary, non-competes are highly negotiable. They will in fact increase the cost of healthcare, which we are trying to fight against. They protect the sizable investments of the hospitals that ask for them to be in effect, and they provide a much greater sense of stability to a workforce rather than having folks hopping from one employer to another. Thank you.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Carrie Richard. I'm here on behalf of MedStar Health, Inc., where I am Senior Vice President and Executive Deputy General Counsel. I also have been a labor and employment lawyer for more than 30 years. I won't tell you exactly how many, in the state of Maryland and representing healthcare organizations and actually veterinarians, as it turns out. So I have an interesting perspective on this, perhaps. What I want to focus on today is just a couple of key points. I won't be repetitive of my colleagues. One is the testimony we've heard today is largely a story of worst cases and largely by bad actors. The industry, the healthcare industry, is generally not full of bad actors. You're looking at the three largest probably employers of physicians in Maryland sitting here today. We are a nonprofit. We are incented to employ physicians in order to provide care for people in the communities. The Affordable Care Act, Maryland's total cost of care, encourages us to provide care for whole populations before they need hospitalization and hopefully to avoid them needing hospitalization. That is part of our mission. And to align with that, I'll use MedStar as an example. Over the last 10 to 12 years, we have invested in employing more and more physicians who are located in the communities where our patients live. We currently employ 2,600 physicians, all of whom have signed a non-compete. They are deployed across 700 different points of access in Maryland. That covers 225 zip codes and 17 counties in Maryland. In investing in those sites of care, we've made investments between $500,000 and $1.5 million just to employ one physician to provide care at that location. In addition, we have a ramp-up period of about 2 years for every new hire. And that is why our non-compete is 2 years. In order to preserve the goodwill we've invested in to assure our locations can remain open, even when our physicians choose to leave, we require a period of time of protection to be allowed to recruit and retain another person and keep that office open and running and provide care to those patients. Note that we don't apply our non-compete when we ask a physician to leave. We only apply it when they choose to leave. And the reason for that is we want physicians to stay. And for that reason, I would ask you to support or to oppose the Bill 1388. Thank you.
Madam Chair and committee members, I appreciate the opportunity to get in front of you today. My name is Dr. Bill Regine. I come to you today as a president of the University of Maryland faculty in the School of Medicine. Eyes wide open. Typically, we invest at least $1 million in the recruitment of a new faculty. That faculty becomes part of our faculty workforce that is highly specialized and highly skilled and often sought out for all kinds of expertise and in delivering innovation, research, and care to the citizens of Maryland. This bill would completely destabilize that ability to provide the ongoing education and innovation. Eyes wide open. We have a fixed set of dollars that come into the state for healthcare resources here. If more dollars are used to increase the compensation of physicians, this bill would literally create sports free agency then there would be even less dollars, and we're already on a thin margin to drive innovation, research, and educating the vast majority of physicians who practice in the state of Maryland. As I listen to all that people said, it seems to me, keeping in mind, and didn't see anyone mention, we have this very unique payment system in the state of Maryland. We actually are an experiment that the nation currently is looking at very favorably. Given the risk of destabilizing the economics of that and continue to provide research, education, and innovation, it seems that you would want to take this into studies. There are all kinds of things I heard today that can be compromised, and we can work with both sides to find common ground. One, you could potentially modify the mileage, 5 miles, 7 miles. You could potentially modify the requirement. You could require that patients be notified if a doctor leaves and where they might be going to. You could actually focus this on the low compensated primary care physicians in which access is greatly needed, and limit it and not allow it for the highly compensated physicians who will only become more compensated in this legislation. I'm happy to take questions after.
Thank you, Madam Chair. Peggy Townsend on behalf of the Hospital Association. In opposition to this bill, I want to go back to what Senator Reedy was emphasizing. This is the first time you've heard this subject matter. And I can't overemphasize the significant disruption, the potential for significant disruption to the healthcare labor market in Maryland. This is not a little fix, quick fix. This is major disruption that we could incur. It could quite possibly have unintended consequences. Does it leave Maryland at a competitive disadvantage to other states? Would we experience a brain drain? Does it conflict with the new FTC proposed non-compete clause? Does it apply to non-disclosure agreements, non-solicitation agreements? Does it apply to non-practicing providers, those that are in administrative roles, those that are teachers, researchers, tech companies, pharmaceutical companies? Does it apply to those situations? And then the last thing I do want to emphasize is the impact of private equity in the marketplace today. This is what has been changing. And these are for-profit private equity companies that go in and want to cherry pick high value types of physicians across certain specialties. And as you heard, these groups don't have to do uncompensated care, don't do charity care, don't have to do a community benefit analysis, etc. That's all left at the back end to the hospitals. And that's the competitive disadvantage that we see that's changing the marketplace today. So for those reasons, we'd ask for an unfavorable report.
Thank you. We have a question first from Senator Reedy.
Thank you, Madam Chair. And to Dr. Regine, you brought up an interesting point that earlier, one of the folks who testified talked about how law firms work. And it jogged my memory to ask you this. So you mentioned the point about if you required, notification of customers that someone's left the practice, that might be a way of, there's some interesting ways I guess my question would be, would you agree that you got a lot of you are up here representing hospitals, and it seems like there's a separation between what you all have to do because you are, number one, in a fixed amount of money. Also, you are investing significant funds in bringing a surgeon or a oncologist or whoever here. So that's maybe a little bit of a different argument than a very specialized type of, say, veterinary medicine. Or, is there some room here to?
Well, absolutely. I have a lot of feel for the four-legged animals, and when I listen to that, I can understand maybe there's got to be a common ground here, right? When I think of all of the investment that we have to make and thinking that we have a fixed set of dollars that come into the state for the physician part of healthcare, you will actually get less doctors. You're either going to get less doctors who are more highly compensated, or less doctors because they're not going to come in because there's not enough dollars to fund them all. It's just simple math. We have a fixed pie of dollars that come into this state. So this should be patient-centered bill. I absolutely agree. The ideal that if a physician leaves, a patient should be given a notification, your doctor has left. This is where they're actually going to practice. But what wasn't mentioned today is healthcare today is typically multi-specialty care. We call it multidisciplinary care. So often when a patient with cardiac disease or heart disease loses a doc, it's not just that they go see that one doc. There's a whole team of docs that are there for them and ready to take care of them. That's the typical way in medicine.
And that's different in a lot of ways than maybe somebody who's going to see a particular type of medical practice that specializes in one thing, or a veterinary practice. Although veterinary practice sometimes has that approach too. So, okay. No, it's just, yeah. Thank you very much.
Mouse?
Dr. Conover, we were talking about continuity of care. From your experience, I mean, how does, if there were, if these were prohibited, if the non-competes were prohibited, in your opinion, how would that affect the continuity of care, especially for someone like in our district, District 37? Perhaps you're not the right witness. I picked you based off of your introduction, and there may be a better witness to respond to this. And in a rural area, because the Eastern Shore is our district, and the other senator from the Shore is not able to be here because he's got a bill on the House side today. But this is a particular concern for a lot of the residents in our district. When they have a doc, and if there were not, if these non-compete clauses were prohibited, how would that affect, from your opinion, our access to care on the Shore? And I got one other follow-up.
So typically non-competes they have a geography and they have a duration. 1 year, 10 miles, 1 year, 20 miles. You've heard 2 years earlier. And in most cases, in non-competes that I've been involved with, those are very modest and reasonable. We're not doing statewide non-competes or nationwide non-competes. And so provider, we're simply looking to avoid poaching. We're trying to avoid one system poaching from another, one company poaching from our stable of doctors. We've made major investments, as Senator Reedy noted, major investments, $1 million or more in office staff, in recruitment, in signing bonuses, just to get providers to come here. And remember that Maryland remains in the bottom decile of the country as far as physician reimbursement goes. And so the makeup of those additional dollars is typically coming from the hospitals. And so you're going to see an increase. I say that this will cost more because the continuity of care that you're speaking to will be negatively affected, because those providers will be more flexible in being able to leave the Eastern Shore and go somewhere else and practice elsewhere. We've spent a lot of dollars to recruit them and to keep them on the Eastern Shore, and we want to very much keep them there. That's our mission as nonprofit health systems. So we are trying to preserve the corpus of providers on our medical staffs providing the care that we have, and not looking to get into bidding wars with private equity firms over talent that may leave the area or the state for richer opportunities.
Dr. Regine, I would offer you to answer the question, but we have a rule. You can only ask one witness a question. So I don't want to violate that rule. But thank you. And I had another question for you, Dr. Conover. With the non-compete agreements, are there any other legal mechanisms in employment where hospitals could somehow protect their investments? In other words, if there wasn't a non-compete, could there be a payout? In other words, we're going to pay you in to come into the system, and if you're not here for, say, 15 years and you're going to leave early, then you would have to reimburse us for the expenses that we've invested in you. Are there other things besides non-competes that would perhaps be an incentive to keep the doctors?
Sure, it's not a great recruitment tool to put a big sticker number in front of a potential recruit and say your departure will obligate you to $50,000, $75,000, $100,000 repayment for our investment. And again, I'd argue that the size of the investments are actually significantly larger than that. Contractually, can those be done? Sure. Practically, not really.
I grew up around a lot of doctors. best friend's father was an orthopedic surgeon, and they were all doctors. And, you know, when you're around a group of doctors, they can give you an earful and none of them agree, right? But they're wonderful. It was a wonderful experience growing up around them. But from your position in bringing doctors to the system, do they usually come to the system? I'm unfamiliar with this. Do they come to the system, or do you have to go find them?
We're typically recruiting. There is a physician shortage nationwide and in Maryland in multiple specialties. And so we are actively trying to hold on to the doctors that we have. And that's why I speak to the pernicious effect of private equity, which has a different financial obligation as well as a different business model. And that is negatively affecting the hospitals and the physician corps in this state. I encourage you to look more closely at that and its impact on us. Non-competes are one tool that we have to basically keep providers in the system and protect our investment. Private equity is a significant problem in this state and across the country.
Thank you.
Senator Ellis?
Yeah, thank you, Madam Chair. And Dr. Conover, you're it. Because you mentioned private equity, and this is a very interesting topic. And a quick question, you mentioned 48 nonprofit hospitals. How many private equity hospitals are there in Maryland?
0.
Okay. So I thought you said they're the problem.
There are no for-profit hospitals in Maryland. The entire Maryland health system, the hospital system, is regulated by the Health Services Cost Review Commission, which has essentially a capitated payment of global budgets.
Yeah, but you keep saying that the private equity hospitals are the problem.
No, the private equity hospital, there are no private equity hospitals.
So how could they be the problem in Maryland?
There are private equity groups. Those private equity groups come and recruit oncologists and gastroenterologists and highly specialized surgeons. They take them into private practice, and they typically want them to work outside of the confines of the hospital. And so it becomes more challenging and more expensive for the hospitals to provide those services in competition with private equity, who have a different business model and no obligation to provide charity care in the process.
Yeah, thank you for breaking that down. So these private equity groups, when you say groups, they're physician groups that have surgical centers in their
correct urologists, GI docs, all of them. Yeah.
And they're the ones who are poaching your specialists.
In many cases, yes, that's correct.
Okay, thanks for clearing that up, because I was curious about that fact. So why is it that our hospitals, all nonprofits, cannot compete, cannot offer better pay, cannot offer better conditions? Because in private industry, even in the military, as Air Force officer for many years, we have a shortage of certain specialists, pilots, even doctors. You offer sign-in bonuses or incentives for them to stay on in those very productive years. The experienced pilots who can fly that Air Force One or Air Force Two, and they're very in demand in industry. To keep them, the Congress allocate, hundreds of thousands of dollars to incentivize those people to stay. Why can't our hospitals, elite hospitals and medical facilities do that in Maryland?
I hope I've got as long as I can to answer that question.
30 seconds.
Look, I'll tell you that there is someone mentioned cherry picking before. These private equity firms are cherry picking physicians and services, taking them to the outpatient arena, and increasing the cost of healthcare in the process by doing that. We are not, every one of us is a nonprofit hospital. And we work under a global budget, which means we don't get paid for more volume. There is a fixed amount of money that hospitals get. There is no incentive for doing more care financially. And those fixed amounts of dollars create a challenge for us that private equity doesn't have in the unregulated environment.
Okay, yeah, thanks for that answer. Thank you, Madam Chair.
Thank you. Now I have a few questions. I might just start down the line here. I think, Dr. Regine, so because we have the waiver in Maryland, which no other state has, that's the reason we need non-compete, because of the waiver?
Do we need, I'm saying non-competes. Without them, there is given the limited pie of dollars to take care of patients, and then thankfully, we're grateful we have Johns Hopkins and University of Maryland who has to do the research, the innovation, bringing the state-of-the-art technology and educating the physicians. Hospitals have dollars that can only be given to so many things. So if the dollars are used to raise the salaries of physicians, because once you let go of non-competes, it'll be like sports free agency. You will have higher salaries that you have to support. You have to decide if you're going to support the salaries, which means there will be less dollars available to invest in research, innovation, education, and bringing the latest gadget or the latest technology to Marylanders, because you're trying to keep up with a back and forth of physician salaries.
One of the people that testified said that it's more difficult for us to get doctors here because we're using non-competes and other states aren't, and it's hurting us in recruiting.
Yeah, we have non-competes at the University School of Medicine. That has not been an issue. To Scott Conover's comment, typically they're negotiable. Also, we also vary. Like for our primary care docs, it's less than 7 miles. For a high specialist, we do it 10 miles. This idea that you have non-competes that extend beyond the state, or somebody said 60 miles, like, of course, that's ridiculous. And again, it seems like, and when you mentioned, here's my chance, Senator Mouts, when you asked about rural Easton and keeping docs, well, you could create the rules such that we have defined areas of underserved or rural Maryland, right? In those areas, you could say a non-compete would have to be limited to 5 miles. Like there's ways to deal with these. I'm just worried about the economic impact that you will end up having less physicians here. You will decrease access. And again, the other exceptions you can make, Madam Chair, is for the primary care docs who have the lower wages. Absolutely, we need to find ways that we can eliminate non-competes. And I think that was the ideal around low wage earners. We have a relatively group of physicians who get lower wages. We shouldn't have non-competes for them at all.
Thank you. And Pegeen, when a doctor has left a practice and is still in his non-compete, her non-compete, can they come back to the same hospital and admit patients? Can they have
I do not know the answer to that question.
Okay. Could you find that for
Carrie,
me?
do you
You don't have to do it now. We're not going to vote today, but we could get back to you.
I can
Just
answer the
curious, because
question.
they could be, as Dr. Regine said, they could be 5 or 7 miles away and still want to have patients admitted to the same hospital that they've been working at. So I'd like the answer to that. And Carrie, I had a question for you. So does it matter how long a doctor works at a hospital? Let's just say somebody's been there 10 years and now they want to leave. The non-compete still comes into effect as they leave, right? So there's no limit to how long they can practice.
Correct. Non-competes generally apply throughout the term of employment and for 2 years after. However, as I mentioned, the MedStar non-compete has a number of large exceptions, right? The first is if we ask you to leave because we're not interested in supporting your service line, we don't apply the non-compete. 2 is if you get another job in the restricted area, but you can explain to us how it won't unfairly harm us, i.e. you won't be poaching our patients and our employees and things like that, we waive the non-compete. It's in the written non-compete that they can ask for a waiver and we will grant it if we won't be unfairly harmed. So we do work with people because we want physicians in the community and we hope they want to work for us, but you get a lot more with honey than vinegar. So that's our approach.
So in most cases, when if a doctor does leave, they can't take their patients with them.
So it's a patient's choice.
Okay.
We notify every patient that their doctor has left and where they have gone, and we do not take any steps to stop a patient from going.
Okay.
We do offer them the opportunity to stay with us if we can, in fact, provide the care they need.
Mr. Conover, Dr. Conover.
Mr. Conover.
Is that also true at University of Maryland?
Absolutely.
And how about at Hopkins? Is that also true at Hopkins?
That would be the case as well.
Okay.
There's no restriction from a patient seeking the continuity of their care with their physician.
Thank you. I broke my own rule first time. Thank you very much. Are there any other questions for this panel? Seeing no questions, that ends this panel. Thank you. We have three more virtuals and one was a favorable. So let's bring up Mr. Joseph Marine or Mr. or Dr. Joseph Marine, Dr. Marine. If you unmute and give us your testimony, please.
Hello, can you hear me?
Yes, we can hear you.
My name is Joseph Marine, honored committee members. Thank you for hearing my testimony. I'm a cardiologist practicing in Maryland for the past 19 years, as well as the immediate past president of Maryland chapter of the American College of Cardiology. During my tenure, I've heard from a number of cardiologists in the state who have been adversely affected by non-compete clauses in health system contracts. These are often onerous and non-negotiable terms which limit the ability of doctors to change employment without having to leave the state, contributing to our healthcare workforce shortage. They contribute to a captive workforce culture in healthcare. Non-competes also sever valuable physician-patient relationships built up over many years. As chair of the ACC Board of Governors in 2021, I co-led a work group which found that the great majority of cardiologists in the US find these clauses to be non-negotiable, harmful to physician-patient relationship, and contrary to physician well-being in the public interest. I know one cardiologist who was recruited into a Maryland practice to perform a certain type of complex heart procedure. When he found that his opportunity to use this procedure was very limited within his group, he was forced to pay a six-figure buyout to move his practice to a center that could support his specialized skills. I know another cardiologist who moved from one health system to another and was required to practice 20 miles away to observe a non-compete for nearly 2 years, inconveniencing, in some cases, losing patients needing highly specialized care. I know several other cardiologists who were forced to leave their home states to observe onerous health system non-compete terms. Numerous organizations, including the Federal Trade Commission, the American Medical Association, and the Maryland State Medical Society, have now recognized that non-compete clauses are an unreasonable restraint of trade that are being abused by large corporations for private advantage at the expense of patients, workers, and the public good. Opposition to this bill on the grounds that it would cause significant disruption to Maryland's healthcare market is not supported by the facts. 12 US states, including California and Massachusetts, have laws barring or severely limiting physician non-competes and retain thriving hospitals, health systems, and physician practices. Maryland should join them. I ask for a favorable report SB 1182. Thank you for your consideration.
Thank you. And Dr. Marine, I have a question based on what you just said. You said 12 states have non-competes, but 12 states don't have the waiver. Only Maryland has the waiver. Do you think that makes a difference?
I do. I don't see why it would make a difference. No.
Because of lower payment to doctors? Lower.
Well, there's lower payments to hospitals. Physician payment in Maryland tends to be on the low side, from what I understand, compared to other states already. But I don't understand why having a level playing field with non-compete, that no employer can use non-competes would be more harmful in Maryland than any other state.
Thank you. Do I have any other questions for Dr. Marine? I don't see any other questions. Thank you for your testimony. And that does end the hearing because our two unfavorables are not on virtually. So we are finished the hearing on House Bill 1388, and that ends our hearings for the day. So we'll give Tammy a few minutes to get ready for voting.